Hey, on today's criminal law Q&A, the question that I'm answering is, can you be convicted based on someone's word alone? And the short answer to that is yes, you can. The way Louisiana law reaches the issue is that there will be a jury instruction that tells the jury specifically that you can convict based on the testimony of a single witness if you find that witness to be credible. Now, this is logical. If you think about it, there are certain things that only take place between one-on-one with the offender and with the victim. For example, there's a lot of date rape cases. There would be almost impossible to even prosecute that if you couldn't rely on just the alleged victim's testimony alone. Also think about some of your drug cases, not your big ones, but your smaller ones, where maybe it's a police officer that's pulling someone over on a traffic ticket or is responding to some other investigation, and he finds drugs on somebody, right? Well, if you needed more than one witness, especially in the land of time where not everyone has body cameras, you would never be able to prosecute those cases. Now, historically, you got to go back to the Old Testament in the Bible, where they say that you need the testimony of two witnesses to convict somebody. And that actually becomes important. I saw this a lot in New Orleans as a prosecutor. When you're picking a jury, there are some people whose religious beliefs hold that very, very dearly. And they will tell the judge that they need more than one witness because the Bible says you need at least two. Well, in those situations, those jurors would be excused for cause during the voir dire process because they cannot follow the law. So that was always something important to discuss as a prosecutor in New Orleans, was to get that out. And then with the other issue now, as a defense attorney, you're also dealing with one-on-one testimony as well. Because jurors will say, well, I can believe one person if there's some other type of evidence, whether it be a body camera or it be DNA. And the law simply does not require that to be the case. So if a juror cannot follow the law, they cannot serve on there. And I'll conclude this question and answer by just reminding you that there's two categories of evidence. There's direct evidence and circumstantial evidence. Direct evidence is something that the witness sees, hears, smells, or says. Circumstantial evidence is an assumption based on a set of facts. So you want to know it's raining, people come in wet carrying umbrellas. You can infer from observing wet people with umbrellas that it may be raining outside. So anyway, that's today's Q&A. If you have any questions, you can email me at the link below.